So we've all been at a party, or more likely on an airplane, when someone asks us, what do you do for a living? And you always hesitate to answer that question because you know the response that's coming. Oh, those poor kids, those parents are so awful. Or my personal favorite, it must be so hard, so difficult. How do you do what you do? We know that the public envisions child welfare cases as those heinous examples that they see on the news. Children locked in their rooms, starving, or where law enforcement needs to break in, and we've got open drugs on the table, guns whirling around the room, and we need a SWAT team and a flak jacket to remove these kids. Where I could send my 10-year-old in, who could easily conclude, this is not a safe environment for these kids. That's what the public thinks. We have to deal with that reality. But we, in child welfare, know that the vast majority of cases don't come in under those circumstances. We're at a critical point in our profession where we're inquiring deeper and deeper into what would have, could have, should have been done to keep these kids at home safe. But we have to confront the fact that we're dealing with the public and the media and political pressures that don't understand that. So, the first assertion I'm going to make is that the legal community, judges and attorneys, are woefully unprepared and unskilled in assessing safety. Safety is the only criteria when we're talking about removal and reunification. So what's the goal? We've popped up on the screen, and I can't get that much into content. I've been schooled, try to get into content, but the content is in the Child Safety Guide. Here are the goals. Deal with an over-removal and an under-removal problem. The over-removal problem. We've got kids in care that never needed to be placed there in the first place. We could have implemented an effective in-home safety plan to prevent the removal. 2, we have kids that initially needed to be placed in care that are staying there. We've got unnecessary delay. They're staying there for too long, and we could get them home because the legal community, judges and lawyers, and I include myself in this, and I'll tell a little vignette in a second about that, where they could get out of foster care earlier, but also the under-removal problem. We have kids at home with either ineffective safety plans or no safety plan at all that are really not safe. And the legal community needs to understand the safety criteria in order to, as I like to say it, said more simply, get the right kids in the right beds. So, the first problem, and I've got a 3-part test that we're going to talk about, and everyone in the legal community wants to get to the 3-part test. But first, and this is, don't we? I got a 3-part test. Let me take notes. The first problem is insufficient information. I see petitions around the country, the initial removal petition, where we have basically the maltreating incident and mom's using drugs, and that's it. Well, relevant evidence, it's not very revealing about what's actually going on in the family. Worse, on the back end, we see case plans and we see court reports with irrelevant information. Let me give you an example. When I was in practice, 6 months into a case, I get this court report. Mom blew up at the social worker in the McDonald's, and goes on. And I didn't know what to do with that information because I didn't have a framework for understanding safety. While inappropriate, it's not relevant to safety. I saw it cut and pasted at 9 months and at 12 months. At the 12-month hearing, I kind of snapped. And I shouldn't have said it, but I said to the judge, so mom blew up 6 months ago at the McDonald's. First of all, why were visits supervised by the caseworker at the McDonald's? Why wasn't the foster parent supervising that visit? Why wasn't grandma supervising that visit? And I kind of snapped and I said, listen, she blew up the social worker. I don't like her either. I find her patronizing. No, I mean, everyone laughs, but my point is we're basing in the legal community, and attorneys and judges need to really raise the bar and to get real about we do not have sufficient information about these families. And so what is sufficient information? I'm going to blow through it quickly because I'm running out of time. The maltreating incident, important. But we see an almost obsessive-like focus on the maltreating incident. I see it repeated again and again and again. That is evidence with regard to the safety threat, but in and of itself is not that revealing. 2, surrounding circumstances around the maltreating incident. What was the parental intent? How does the parent explain it? Do they acknowledge it? What's the history of it? So even I'm only of 2 of 6, and you might already be thinking, gee, I don't even get that in the initial petitions. 3, beyond the maltreating incident, what are the overall parenting disciplinary practices? 4, beyond discipline, how does the parent generally? What's the empathy towards the child? What's the connection towards the child? 5, how does the parent function day to day? Community relations, social connections, self-care, employment, housing. And 5, how does the child function day to day? So obviously school performance, both peer relations as well as academic performance. So even as I'm saying that, and it's a whole chapter in the book, you think to yourself, gee, I don't really get that kind of information. So how are we basing decisions? What's the 3-part test? 1, safety threats. So if you look at the guide, they're not a case type. It's not a sex abuse, physical abuse, neglect, but they're behaviorally stated. So a safety threat is expressed by way of a condition that's observable and clearly described. The threat is imminent, the effect is severe, and that defines a safety threat. And you can look in the guide to see examples. Second, is the child vulnerable to that threat? And there's a danger of oversimplifying vulnerability by looking at age alone, but we've got physical and mental health and peer communications and lots of examples. Third, protective capacities. Some people call these protective factors. They fall in three categories: cognitive, behavioral, and emotional. So cognitive, does the parent understand? Can they articulate a plan to protect the child? Do they understand their protective role? 2, it's not enough to know what to do, you have to actually do it. That's behavioral, actions, performance. And this is all what evidence the attorneys need to gather to support the presence or the absence of behavioral protective capacities. 3, emotional protective capacities. How connected is the parent with the child? What's the bonding? What's the empathy? And how is the parent performing in his or her own life? You can see from that short synopsis of the 3-part test, if you don't have information on the case, you cannot possibly assess safety threats, vulnerability, and protective capacities. So, what do we do about it? The definition of an unsafe child: insufficient protective capacities to manage the presence of safety threats, and the child is vulnerable to the safety threats. Let me say something else that might be a little controversial, but it's certainly true. If you really look at the safety threats and think about our own history, either as children growing up or as parents raising kids, from time to time, there were safety threats present in the home. The examples of safety threats: parent is violent, impulsive, not performing proper parenting duties, responsibilities. From time to time, that happened. But the child was not defined as unsafe because there was someone, an adult, maybe a parent, maybe not, within the home who was managing the threats, okay? So once you have an unsafe child, we need to ask ourselves, what do we do about it? It doesn't automatically mean removal. And so many judges, and I have to look right at the camera here because I know there are judges listening, just because the child is unsafe doesn't automatically mean we need to remove the child. We need to consider whether or not an in-home safety plan will suffice. And there's a whole chapter in the book on in-home safety plans. Once we determine that an in-home safety plan is not practical, sustainable, or feasible, then we're looking at an out-of-home safety plan. I will not use the term foster care. You know why? Because it's an out-of-home safety plan. That's what foster care is. And I think something happens once the child is put in foster care. We call it the raising the bar phenomenon, where if this parent was performing at this level 12 months into the case, the child never would have been removed. But something happens, and I don't mean this disparagingly as I look in the camera. The judge says, hey, Warden June Cleaver doing a really good job with the child. I can't quite put my finger on it, but the child's not ready to be removed. Well, we've lost the point, which is that an out-of-home safety care, an out-of-home safety plan, foster care, that's what it is. So once we're at an out-of-home safety plan and we're looking at foster care, 3 issues kick in: visitation, case planning, and conditions for return. And I'll move quickly. I'm going to look right in the camera. And this is really important. If I make a difference with one judge out there, that's a difference. The default for visitation should never be supervised. That's not a good default for supervision, for visitation. It should only be supervised if it's justified by safety considerations. How do the threats emerge? What's the volatility of the threats? The default for supervision is always unsupervised unless and until we can identify safety considerations which justify the supervision. If it has to be supervised, does it really need to be the child welfare agency? Or could it be grandma? Could it be the foster parent? Can we do a better job recruiting foster parents who will welcome the birth parents into the home in a more natural situation where the parent can see good parenting modeled? Supervision is a safety requirement. 2 is case plans. My time is clicking down. I have a couple more key points. Case plans. The purpose of a case plan is to reduce or minimize the safety threats and enhance the protective capacities to manage those threats. We have got to move away from case compliance. It's easier for courts, it's easier for judges and attorneys to evaluate how many parenting classes, how long have you been clean. But isn't what we really want to know is not, did you get to 10 out of 10 parenting classes, but what difference does it make? Or you made it to 2 out of 10 parenting classes, but you have other community supports. You've done other things, and you've enhanced your ability to take care of these children. It's harder to assess, but that's really what we need to assess. The other thing about case plans beyond case compliance is that as we're reducing the threats and enhancing the protective capacities, we've got to evaluate that in a different kind of structure. And the final point is conditions for return. Vague, imprecise conditions for return leads to bad outcomes. We tell parents, follow the case plan. Oh, do this, oh, my time's up. Do this, and you're gonna get your kids back. But then they don't. So we need more specific conditions for return that are tied specifically to the threat. So I apologize for this being too content heavy. I appreciate your time. Please look at the guide, and as my federal project officer is coming up here to exit me off the stage, I will tell you, technical assistance is available. We're very passionate and we really feel like this can make a difference. So thank you for your time.